Further hearing in the appeals, Lewin and Diah and the Indicom appeal.
I look forward to the day when we come in for the second day of the hearing and there isn't a new piece of material on our desk.
My lord, I'm working towards that situation.
It'll only take another century or so, I think.
Seek progress, not perfection. Can I just indicate that my lords, that the note is really trying to grapple also with the Section 28 point that I promised I would seek if I could address.
Oh, it's very welcome.
Oh, I'm great. My lord, the other thing is that there is a short schedule which just sets out the cases we've referred to, and one further one, Chocolingo, that the question, this is the question of authorities, whether there's express provision for prosecution, what test is applied, what factors the court regarded as significant, and was there indeed...
The sad truth is, Mr. President, I'll be extremely disappointed when I arrive and there's not any new item of material, because this is testimony to the liveliness of the debate yesterday.
My lord, yes, and I had promised to address Section 28.
Yes.
So, my lord, first of all, if I can take you to the additional speaking note, we say it is significant the Police Federation accept that a prosecution under Section 33 can be conducted by the Commissioner or his officers for misleading statements or obstruction. So Section 33, of course, provides in for an offence where you willfully make any false statement. That's at page 934 of the bundle, volume 1. And then if without lawful justification you obstruct. So it's accepted that though the statute is silent, it follows from the general common law principle that a public authority can prosecute to facilitate and protect the discharge of its functions, that Section 33 prosecutions can be initiated by the Commission itself. So that really disposes of the suggestion that because it's a public authority rather than a juristic person, it can't prosecute. It can prosecute, provided it's in the discharge of its functions, or it's necessary to the discharge of its functions. We say at 1.3 from there it is a short and perfectly logical step to conclude that the Commission can also, despite the same silence in the statute, prosecute those members of the security forces whom its investigations reveal to have committed serious offences. And the one point that does emerge from the concession is that the fact that the statute is silent on any power to prosecute whilst expressly providing for a power to investigate cannot settle the issue, because otherwise there wouldn't be a power to prosecute Section 33. Therefore, the real question we submit is the scope and extent of the general common law power of a public official to prosecute in order to facilitate its performance of its overall functions. And just stressing the point again that in determining the scope and nature of the Commission's overall functions, the Court can have regard to the fact that the Commission itself, as part of the state, has a duty to ensure compliance with the right to life.
May I ask you, you would say not just power but function as well?
Yes, function.
Power and function.
Yes, power and function.
Prosecute under Section 33.
Yes. Under 33 and and to prosecute any misdeeds which its investigations reveal.
Yes,
and then, my lord, we just put one short case from the board itself in the Neville Lewis case. It's at page 78F. It was made clear by Lord Slynn that it's at 7. In addition, Jamaica ratified the American Convention on Human Rights, and it is now well established that domestic legislation should be, as far as possible, be interpreted so as to conform to the state's obligations under such a treaty. And then there's various citations. So we would say that necessity to ensure compliance with the requirements of the IACHR has been recognised by this board to be relevant in interpreting a statute. and so that concludes the first point, that it's within the scope of the authority's overall functions. Then section 28, the first point is perhaps the most important point, that we would submit that the process of reasoning from the somewhat labyrinthine provisions of section 28 to the conclusion that Parliament has necessarily excluded prosecution by Indicom itself is, we would say, both perilous and impermissible as a process. Only clear words would exclude the common law power of a statutory authority to initiate a prosecution in support of its overall functions. So that's the point that my Lord Hodge put to us yesterday afternoon, and which we would respectfully submit is the most important point. But secondly, if we do grapple with section 28, 28.2 only protects Indicom officials from compulsory disclosure, save in respect of proceedings covered by 21.3, 25 or 33. If the Commission or any officer commence a prosecution in discharge of their functions to bring to justice someone involved in an incident, that's to say not a section 33 prosecution, but a central prosecution for some killing or serious misconduct revealed in the course of their investigations, then voluntary disclosure is provided for by section 28(1)(b, because then the Commission would have the would have the duty to decide whether it thinks it's necessary in the discharge of their functions, which on our interpretation include prosecution, provided it doesn't prejudice the security, defence or international relations. And one can see therefore an ascending level, there's an extra test of whether it would prejudice security, defence or international relations because of the likely sensitivity of the matters in a full-on prosecution for, say, a killing in controversial circumstances. And then if we turn over to 28.2, that we say only protects from compulsory process, and there are similar provisions in respect of the other parliamentary commissions, such as the Childcare Commissioner. And we submit at 2.3, dealing with those in turn, the things that are exempted other than proceedings mentioned in subsection 1 or section 25. To start with section 25, which my Lord Briggs invited us to address, it's not necessarily limited to cases where the Commission has only investigated and the DPP then decides to prosecute, i.e. the case where they investigate, they send a report to the DPP and the DPP prosecutes. It could also cover the situation where the DPP takes over a prosecution initiated by the Commission. There should be a dash pursuant to his powers under section 94 of the Constitution. And in such a case, the Commission member would not naturally be making voluntary disclosure under 28(1)(b), since it would no longer be a Commission prosecution. Therefore, it makes sense to provide for a duty to assist the DPP and for a power to compel disclosure in such section 25 cases. And then that's section 25. That leaves the section 28(1)(a) cases, which are the ones referred to, criminal proceedings under section 33 or section 21(3). We would submit it makes sense when you're dealing with a criminal prosecution under section 33 for there to be compulsory process, because the Commission personnel are going to be essential witnesses of primary fact, since they're themselves centre stage in the prosecution. They're the people who are going to be saying I was obstructed or I was lied to, they're necessarily going to be the people giving evidence against. And so it would follow that there needs to be a duty for them to make full disclosure, specifically provided for in a power of compulsion. And that explains the need to make special provision for compulsory process for such cases in section 28.2. But it doesn't mean that those are the only cases which the Commission can prosecute. And justice can still be done under 28.1b, and as I've said, by the power of abuse and by judicial review if necessary. So we would submit, firstly, it isn't sufficiently clear to draw any conclusions that the general common law right of a public authority to prosecute has been taken away by necessary implication in section 28. And secondly, that one can construe it consistently with there being a power to prosecute, not just for section 33 offences, but for other offences revealed in the course of their investigations. My Lords, those are the submissions we make on section 28. There's just one final point. We respectfully refer to paragraph 63 of the Appellant's case in Diah, which is to be found at page EB page 761, and of the Diah case.
The Diah case?
Yes, of the Diah case. Yes.
Sorry, who's?
It's in my learned friend's case at page page 761. So it's paragraph 63 of my learned friend Mr. Williams's case. I can, if necessary, just take you to the bits of
761, got it.
So it's page 761, paragraph 63. What it says is, when the ICA was passed, there were 4 other commissions of Parliament, namely the Contractor General, the Public Defender, Political Ombudsman, and Children's Advocate. The enabling statutes of each are quite similar. Each statute creates offences for obstructing or uttering falsehoods, and they all provide expressly that if there is evidence of breach of duty or misconduct or a criminal offence, the Commission shall refer the matter to the person or persons competent to take such disciplinary or other proceedings as may be appropriate. And the fact that they're referring it to the persons described as competent to take such disciplinary or other proceedings suggests that those other authorities are the competent people to take disciplinary or other proceedings, whereas the Commission itself is not. There's no similar restriction in the ICIA, and so we say that is a significant indication. My Lords, I've given you the various statutory bodies in this schedule, and then I was just completing our submissions. There was just one final matter in the speaking note, which was about the unincorporated bodies. My Lords, essentially, I was on it at paragraph 8 yesterday. The prosecution have asserted that Indicom has no right to prosecute because it's an unincorporated body, not a juristic person. Well, that's inconsistent with the fact that they're saying that they can prosecute under section 33. So we would say that that is, and it can no longer, we would say, be a good point as you can't prosecute. But the case law makes clear that public authorities which are not incorporated, such as the Inland Revenue, have the power to prosecute at common law, where such prosecution is necessary to give effect to their overall duties. In the Hunt case, as you can see from the schedule, that was an unincorporated association. The Constitution itself, section 94, I should use the word assumes that both persons and authorities can initiate prosecutions. There's no limitation in the Constitution to specify only authorities that are incorporated. And then at common law, a wide range of bodies can prosecute. And I gave you just very quickly the reference to Lord Wilson's judgment in Gujra. Can I take you to volume 2 of the authorities, tab 33? And this is the final point. So if one looks there, one sees at tab 33, page 1316, I think it may be 1317 in your Lordship's bundle, one sees that he refers to the wide variety of bodies that had the power to prosecute privately.
I beg your pardon. Could you give me the paragraph again?
It's paragraph 33, my Lord.
Thank you.
So, paragraph 33 at page 1316. Sorry.
We're back to your electronic bundle.
Yes.
Yes.
1316. I think in some it's 1317.
It is 1317.
Yes. I don't know why I've got my EB is a page behind, but
Well, we did get an email telling us of the
problem.
eccentricities of the
So,
electronic bundles.
always a page behind. So, but 1317, the board will see the appellant does not go so far as to contend the director's current policy eliminates private prosecution. Such are still frequently instituted. The great majority survive his free current tests for intervention and discontinuance. They therefore proceed as private prosecutions or occasionally as prosecutions, which he takes over and continues. Other public bodies, such as the Office of Fair Trading, which prosecutes those who practice wrongful forms of selling, Transport for London, which prosecute evaders of fares, apply the reasonable prospect test. So does the Royal Society for the Prevention of Cruelty to Animals, a private registered charity, the target of which prosecution is self-evidence. Retail companies often prosecute shoplifters, and although there is no firm evidence before this court as the evidential test which they apply, the CPS seems not to intervene, and indeed to be more than content, thus to be spared entry into that sphere of prosecution. Other private bodies who sometimes conduct private prosecutions are identified in an illuminating article by Dr. Lee. We have that article if the board wishes to see it, because it's twice cited in this judgment. But it refers to actually trade unions even, these threatening prosecutions. There is a residue of prosecutions brought by individual citizens, often for alleged assaults upon them, which survive the CPS tests, or of which indeed the CPS never comes to. That's because the CPS was applying the test of better than even's chance of successful conviction. I may have misinformed the court yesterday. I understand from my learned friends that the DPP certainly has a reasonable prospect of success test in Jamaica and may well interpret that as better than evens.
What about the public interest test?
Yes, I think that too. My learned friend, Mr. Williams, who was the DPP in the British Virgin Islands and has prosecuted many times in Jamaica.
So it's essentially the same as in
Yes.
United Kingdom.
Yes, but whether they.
When I say the United Kingdom, I of course exclude Scotland.
Yes, Scotland Scotland has special provisions, of course, my lord.
We don't have a DPP.
Yes, and that's referred to by Lord Mance. Can I just take you to the similar passage in Lord Mance's judgment, paragraph 89, page 1328 in your Lordship's bundle. Paragraph 89, quite apart from police prosecutions, however, a not inconsiderable number of bodies and some individuals have to this day continued to institute and pursue truly private prosecutions, as noted by Associate Professor Douglas Hay in Controlling the English Prosecutor by Lord Justice Watkins and Stafford Justices, etc. A research study for the Royal Commission on Criminal Procedure is quoted by Hay, recording that less than 3% of all prosecutions were purely private, about 9% of other prosecutions being for shoplifting by retail stores. And then there is, I think, the reference to the article too. You see, the Dr. Lee article is referred to too by. No, I think we have that article. if the board would wish to see that, it is available. But it really just, but it refers to a number of different bodies.
Paragraph 90, it said it's a fundamental constitutional principle of individual liberty. At paragraph 90, it said it's a fundamental constitutional principle of individual liberty.
Based on the rule of law, yes. It's part of the notion of access to the courts, which is referred to in the Chocolingo case, which we've also given in the schedule. And I think at page, you can see at page 3 of the article, there's a reference to the NHS Security Management Service bringing prosecutions, and trade unions have threatened private prosecutions to attack their members, friends of the earth. Now, all I'm saying is not every of one of the authorities is necessarily an incorporated one. Many of them are, but not all. And we know from the Hunt case that is not regarded as a necessary precondition of prosecution. So, yes, my Lord, I'm grateful that there are a number of statements of the fundamental nature of the right to private prosecution, both in Lord Mance and in Baroness Hale in their dissenting judgments, but also in my Lord Kerr's judgment, Lord Newburger at paragraph 60, and in Lord Wilson's judgment too, where he refers to the Gourier case at paragraph 27, page 1315, and the historical right to bring prosecution, and the reference to it as a useful constitutional safeguard against a capricious, corrupt or biased failure or refusal of those authorities to prosecute offenders against the criminal law. So it is a fundamental right, we respectfully submit, which can only be taken away by clear provisions, and it's possessed by public authorities and therefore by this public authority, and the test that's applied is typically whether they're uniquely advantaged to take a prosecution. In the Chocolingo case, which you have in the schedule, the test was whether they had a sufficient interest to prosecute in the administration of justice, sufficient interest in the administration of justice, so it's a lower test. But we respect...
Give me a reference to that, please.
Chocolingo's tab 60, my Lord, and we've referred to the relevant passage in the schedule, but it's tab 60. We've summarised the key passages in the schedule: implied interest in the administration of justice, prosecution not expressly forbidden, and general right to prosecute as explained in Gourier. One sees. So, my Lord, we've given you the relevant passages. Unless you wish me to take you to the Chocolingo case, one can see it was an incorporated body, but clearly the revenue commissioners and some of the other bodies whose power is recognised to prosecute were not. And moreover, the common law power recognised by Lord Justice Rose and by Lord Wolfe in respect of the revenue commissioners was not that of an incorporated body. But for all those reasons, we respectfully submit that there is a common law power in Indicom as a public authority to prosecute, and that it extends not just to Section 33 cases, but to all cases where their investigations reveal serious crimes by the security forces, and that in those cases they can legitimately prosecute themselves. Unless I can assist further.
Thank you very much indeed, Mr.
Yes.
Mr. Small.
It Dear Lord, so the single point that I am to address on is the interpretation of Section 20.
Yes.
But there were some questions asked in the course of my friend's submissions, which I wish to link in with this interpretation.
Right.
My lords, I have set out my submissions in a speaking note, which I hope will
Thank you very much.
avoid the need for extensive note-taking.
Perhaps I can take the opportunity to reiterate what my Lord Briggs said yesterday, if these can all be sent electronically.
Thank you.
Yeah.
I'm told that they can't.
Well, I know that Mr. Fitzgerald is very assiduous in making sure that.
Says it's being done.
Good. Thank you very much, Lewin. Yes.
And so I begin by saying that the question is asked. Could your Lordship give me a moment?
Yes.
The question has been asked that it seems strange that the legislature passed legislation which speaks about the investigative duties of INDECOM, but does not say anything about its duties to arrest or prosecute anyone.
Yes.
And we say that there's a simple answer to that question. There is no need to state the common law rights to arrest or to prosecute, as these are well-established rights which all persons and authorities are entitled to and which only are removed by express legislative enactment. On the other hand, the Parliament, faced with the Michael Gale versus Jamaica report, which strongly recommended that the Jamaican state must reform its investigative machinery by providing an investigatory system that is both independent and effective. The Parliament was required to introduce a new regime of investigation. The Parliament is also required to reform the prosecuting system to ensure that there's access to a reliable prosecutorial system. To achieve the first objective, it is necessary to pass express legislation establishing an effective investigatory system. In the case of the second objective, there is a right to prosecute which exists in the common law, and there's no need to establish this right, and the law is that such rights can only be taken away by express legislative effort. So while one understands that one may think it strange that the legislature did not think it prudent to say anything about the right to prosecute, on reflection, it should be clear that the law is that it's quite unnecessary to express the intention to retain the right. On the other hand, to establish the right to conduct independent and effective investigations, it will be necessary to pass legislation to establish such investigation. Without such legislation, there is no established common law right to have an independent and effective investigation. So the above explains why the legislation deals with establishing investigative duties and does not say much about the right to arrest or prosecute. On the other hand, the right to arrest or prosecute has a long-standing common law history. This right is to requires an express legislative declaration removing the right. On the other hand, the duty to independently and effectively investigate requires an express legislative intervention to establish the right and the extent of the duties. And we say that is a simple explanation for the scheme of the INDECOM Act. The Act appears to be focused on the investigative machinery of INDECOM, without saying much about INDECOM's power to arrest or to prosecute. But both of these are well-established common law rights. Having established a duty to investigate the allegations by passing sections 4, 13, and 14, the Parliament also wanted to further expand the rights of the Commissioner and his investigative staff, to give them the additional powers of a constable when carrying out their functions. Parliament took the view that if the commissioners and staff were to be given these additional powers, the safest way to do so was by an express statutory provision. Hence, Section 20, and this section reads as follows. For the purposes of giving effect to Section 4, 13, and 14, the Commissioner and the investigating staff of the Commission staff shall, in the exercise of their duty, have under this Act the like powers, authorities, and privileges are given by law to a constable. We ask you to bear in mind that the Parliament was seeking to comply with the recommendations of the IACHR in the Michael Gale case, which required the Jamaican state to introduce the necessary reforms in keeping with the international procedural obligations of human rights law, and at the same time, in keeping with the fundamental rights of the Charter of Rights in our Constitution. The Parliament was introducing the ICIA, which is in keeping with the constitutional requirements of the Charter. Both of these requirements needed an effective and independent investigatory regime. And I ask the board to note the introductory words to Section 20 for the purposes of giving effect to Section 4, 13, and 14. And we say that those words could not have been used by chance. These are words designed to comply with the procedural obligations for effective investigations required by international human rights norms and constitutional provisions of the Charter of Rights. My friend Mr. Williams has dealt extensively with the submissions as to why the procedural obligations are to be read into the constitutional fundamental rights. Those submissions we submit also will assist the board in interpreting the provisions of Section 20 of the ICIA, as this provision was introduced to give the Commission and his investigative staff additional powers while carrying out their investigatory functions, and to ensure that those functions were more effective as the procedural obligations are designed to ensure. Those submissions demonstrate that not only are these submissions based on applicable domestic law authorities, but to the contrary to what the respondents suggest in their written case, electronic bundle, page 726, paragraph 28, where they doubt the procedural rights upon which the appellant relies forms part of the Jamaican domestic law. But we say that they are grounded in the domestic law authority of the Constitution and also in international human rights decisions applicable to Jamaica, for example, Michael Gale versus Jamaica. Our written case contains between paragraphs 66 and 67 a detailed analysis of the crucial words in Section 20. And we ask the board in its deliberations to consider the submissions set out therein. I don't propose to go through that analysis, but adopt it. We submit that the provisions of Section 20 make it clear that the Commissioner and his investigative staff are given the like powers of a constable in the exercise of their investigative functions, investigative powers, and for the purposes of making the powers of the Commissioner and his investigative staff more effective. This section, by its wording, seeks to ensure that the investigative function is reinforced to include the constable's powers of arrest in the course of investigations, and also for the purposes of holding identification parades. The overarching governing provision of the section are the words, "for the purpose of giving effect to." And we submit that this is the most important provision of the section. What it says and where it is positioned in the section demonstrates its dominant purpose in the legislature's intent as to how it is to be interpreted in the new legislation, which we say was introduced as a result of the stinging criticisms of the judgment in Michael versus Jamaica. Section 20 of the ICA seems to be giving effect to the powers conferred on the investigative staff by sections 4, 13, and 14. So section 20 therefore seeks to add to the powers given by section 4, 13, and 14 in order to make the provision of sections 4, 13, and 14 more effective in keeping with the procedural requirement for effective and independent investigation. We say that section 20 does this by expressly giving to the commissioners and his investigative staff the like powers of a constable when carrying out their functions under the Act. Without the provisions of section 20, they would not have these additional powers. In other words, section 20 seeks to give additional powers to the Commission and his investigative staff, additional powers, authorities, and privileges over and above those given by section 4, 13, and 14. We submit that it is then left to the interpretation by the courts as to what are the powers, authorities, and privileges of a constable that are given by section 20 to the commissioners and his investigative staff. We can therefore submit that the commissioner and the investigative staff have the powers of arrest of a constable conferred on them by the express provisions of section 20. And we will refer the board also to our written case at paragraph 60.
Well, I think probably we can read all of this, Mr. Small. It's not necessary for you to read it out to us. It's very helpful, though. Thank you very much indeed.
I'm much obliged, my lord. I refer you at the end to the two authorities upon which we rely.
Yes, thank you very much.
Lordships will just give me a couple of seconds to set up the lecterns because I'm trying to do this all electronically. I hope it works. So, my Lords, I want to deal first with the prosecution issue, and then right at the end I'll come to Mr. Diah's conviction. And I'm going to deal with both sections, a prosecution for Section 33 offences and a prosecution for what I call an incident offence. So an incident offence describes a prosecution in respect of an offence that arises out of the circumstances that Intercom are investigating. So I'm going to deal with both of those together. And by way of summary, I'm just going to set out the steps that my argument is going to take in relation to the prosecution incident. So we start from the premise that we accept that there is a fundamental principle of individual liberty and of access to the court, and that the right of an individual to prosecute is an aspect of those two rights. But Indicom is not an individual. Indicom is a creature of statute. And as such, and as the Court of Appeal recognised in Securaplan at paragraph 10, and we'll come to that case later, the powers that this creature of statute enjoys are only those that are conferred upon it by the statute that creates it, or by other statutes that may follow and confer more powers, which is not to say that the statute may also confer certain powers by implication as opposed to through its express terms. So Indicom as a creature of statute is entirely distinct from an individual citizen or any other individual recognised by the common law, such as a corporate entity with legal personality, which may prosecute, but as we've seen, it can only do so also in prescribed and limited circumstances, namely that which is allowed by its articles and memorandums of association. The case of Hunt does not establish that, as a matter of common law, statutory and public authorities have a power to prosecute. To the extent, and we'll go to Hunt in some detail, but to the extent that a power to prosecute was identified as residing in the common law in the case of Hunt, and your lordships will remember Hunt was a case concerned with looking at the Inland Revenue Commissioner's powers to prosecute, it appears from the court's judgment that the common law power was actually an aspect of the Crown's prerogative powers, the prerogative powers being an aspect of the common law. And so one's dealing here with an emanation of the Crown, namely the Inland Revenue Commissioners, and it enjoyed those prerogative powers. So far as a creature of statute is concerned, its powers, it is not an emanation of the Crown, its powers are those which it can derive from the statute that creates it, identifies its functions, and provides the scope of its authority to act.
So Indicom was not a creature of statute. It would have the power to prosecute.
If Indicom was not a creature of statute, so if Indicom, let's take the situation of a private citizen and an unincorporated association. So Mr. Fitzgerald identified that an unincorporated association is permitted to prosecute. If Indicom was an unincorporated association, then it would be able to, or its commissioner or whoever, would be able to prosecute at common law. The question then is, on what material could it prosecute? And we have to look to the statute to see what it can do. So it isn't a creature. So you'd effectively have to put ISIA, the Act, completely out of scope and say, can Indicom, as an unincorporated association, a trade union, prosecute for an offence of murder? Yes, it can, but what's the material with which it's going to prosecute? What are the powers? Those powers to investigate derive exclusively, in Indicom's case, from the powers that are conferred under the statute. If you sweep that away and just say Indicom is created by itself, a group of individuals have come together and decided that they are going to conduct this responsibility to investigate the police, then the common law fundamental right will apply to that unincorporated association through the individuals who collectively have come together, and they can bring that prosecution. But the question is, on what? With what material are they going to prosecute?
It's the singular circumstance that they have been created by statute which prevents them from having recourse to the common law right to prosecute.
it's not the singular circumstance. So
What other circumstances are involved?
So Indicom is not, its emergence into the world is not like the Big Bang. It suddenly emerges fully formed as an individual enjoying all the rights at common law that an individual can enjoy. Indicom only exists because it is brought into being by a statute which defines its existence, the scope of its existence, the purposes of its existence, its functions and its powers. And absent that statute, it does not exist, and its powers, therefore, are those that are exclusively conferred under the statute. And we can see this from the cases that we've been looking at, including Hunt, including Secure Plan and Rollins, because they don't start from the premise, well, these bodies are no different to a private citizen and therefore they can prosecute willy-nilly for anything they want to prosecute for. It starts from the premise that they can only prosecute insofar as it is consistent with their statutory functions or their memorandums and articles of association, and in furtherance of and ancillary to those functions. So that's the distinction, an absolutely fundamental distinction. These are not, or rather, a statutory body is entirely distinct from an individual for the purpose of the common law.
Yes, but it's certainly at first blush somewhat incongruous that if Indicom had been a group of individuals who had come together as responsible citizens to carry out investigations on their own initiative, that they would have had full recourse to their common law powers, and because it's been created by statute, Parliament is deemed to have decided that those common law powers would be denied such a group.
And it's not a question of denying them, it is a question of whether they are conferred at all. So that's the starting point. They have
I don't know what the distinction between deciding whether they're conferred at all or denying.
It's a fundamental distinction because it begs the question, are there any pre-existing powers that exist outside the act that constitutes the body and defines its function?
Sorry, I was suggesting that if there had been a group that had come together without the imprimatur of Parliament, that they would have, if I've understood your submission correctly, they would have had the common law powers. But because Parliament has created the group, created the institution, that it has decided that they shouldn't have access to those powers.
So dealing with both points separately.
Yeah.
So if they had come together as individuals and decided that they were going to establish an investigative body, one has to think, and this applies to any individual. At the moment, any private citizen in Jamaica is entitled to prosecute a police in relation to a police shooting. That is the fundamental principle that Mr. Fitzgerald has described. But how could they do it in practice if they are not able to investigate because they do not have the powers to do so? So yes, it is a power that is theoretically available to all citizens, but practically it is not a power that is exercisable in almost all cases, and that's why we see that the power is not exercised by individuals. There are no cases where police officers have been prosecuted because they simply do not have an individual citizen any investigative powers conferred upon them. So the question then becomes, what is the implication of passing a statute that creates a body which is given investigative functions? And the starting point there is that that body has no existence and no life outside the statute that creates it. And therefore it is to the statute that creates it that you have to look for its powers. It is not a private citizen, and it is only if the act itself, which confers its powers, which brings it to life, it is only if that act confers a power to prosecute that it will be able to use all the investigative powers that are given to it under the Act for the purpose of prosecution. Can I come back then to the common law and the Hunt case? So our first submission in relation to Hunt is, as I say, that this was a special case because it is actually an emanation of the Crown and enjoys prerogative powers. But my second point was that, but in any event, the scope of the common law power is not the same. It's not the plenary power that a private citizen has to prosecute. The law, through Hunt, only recognises that such a body has a power to prosecute in furtherance of, in aid of, and ancillary to its functions. And even on the Respondents case, I mean, the Appellant's case, they've been slightly inconsistent here, but on the one hand, Mr. Fitzgerald yesterday was relying upon Hunt and accepting that it's not a plenary power in respect of authorities equivalent to that which rests upon an individual. It is only a power to prosecute for an offence that the authority is peculiarly advantaged to prosecute. That's how he described it yesterday, relying on an aspect of the judgment in the Hunt case. But in our submission, even that is wrong. The ratio of Hunt, and we will go to it, is not as extensive as that. It's not simply enough. It is not a sufficient condition. It's not even a necessary condition that they are peculiarly advantaged, the authority, in prosecuting the particular offence. The necessary condition is that the prosecution aids the authority's functions, or is ancillary to or supportive of that function, and crucially is limited by that function. So, to sum up, the law does not recognise, for good reason, that authorities that are created by statute enjoy the same powers as are conferred upon every citizen to bring a private prosecution. It only recognises a limited right to prosecute in the circumstances as I've described that. And even if there is a common law right, as established by the case of Hunt, it is no different from the nature and scope of the right that falls to be implied into a statute. And that is something which we see from a line of authorities starting with Broadmoor, running into Secura Plan and Rollins, and we will look at those. So it's not about taking away a power, it's about whether a power is given. And because it's about whether a power is given, that power can only be given either by implication or sit alongside the statute under the common law if that power is consistent with and not contradicted by the statutory scheme that establishes the body, confers its duties, functions and responsibilities. And we're going to look through the statutory scheme to understand what duties it confers in relation to Indicom and to understand how it addresses prosecutions of incident offences and offences arising under Section 33. And it is our submission that, having done so, it will be clear that the statutory scheme is entirely inconsistent with there being an implied power to prosecute for incident offences. And we'll see that the statute does address the issue of prosecution, and it makes clear that any prosecution for incident offences is to be carried out by the DPP. So our primary submission is that there can be no implication, and equally this limited right to prosecute under the common law is inconsistent with the express terms of the statute. But our second submission is that in any event, it simply does not fall to be implied because a prosecution for an incident offence is not a prosecution which furthers the functions of Indicom, which are investigative functions. It is not ancillary to those functions, and it is not supportive of those functions, and it is not, or it would not, fall within the requirement that it be limited by those functions, because it is wholly out with an investigative function and follows after the exhaustion of an investigative function. So there is no room for implication of this narrower power that may be implied, or, if we're wrong, sit alongside a statute under the common law. Further, the appellant can derive no support from the right to life jurisprudence or the jurisprudence of the Inter-American Court in its recent case law. And that is because, while we fully accept and assuming that that jurisprudence is directly applicable, or at the very least of highly persuasive authority in Jamaica, what it requires, we accept, is that there be an effective, independent investigation into alleged unlawful force by state authorities, which requires not only effectiveness in the investigative stages of an inquiry, but also an effective prosecution. Doesn't mean you have to convict somebody, doesn't even mean you have to charge somebody, but it has to be effective in the sense that the machinery is up to scratch and has worked effectively and efficiently in the case. We accept that, but there is nothing in the jurisprudence that requires that the body or bodies that carry out the investigative function must also carry out the prosecutorial function. In other words, there is nothing wrong with splitting those two functions between two different independent authorities, as is done in Jamaica, with the investigation under the Act being carried out by Indicom, and prosecutions under the Act being carried out by the DPP, who is herself an entirely independent constitutional authority established under Section 94 of the Constitution. And nor does that lead to absurdity, which is another of the appellant's arguments. There is nothing absurd about a system being established by a state which confers upon one body an exclusively investigative function, leaving that function to the particular expertise of that body, and then transferring the prosecutorial function onto a body which is expert in that particular function, as the DPP plainly is. She has plenary powers under the Constitution to institute a prosecution. And it is worth saying that this isn't a strange setup. This is exactly what happens in England. Investigations are carried out in England by the Independent Office of Police Complaints. Those investigations will then result in a report that will be seen both by the police for them to look at whether or not there should be disciplinary proceedings to follow, but also passed on to the Director of Public Prosecutions to decide whether or not a prosecution should follow. And the IOPC has no power in England and Wales to prosecute. That is something that is done by the DPP and the CPS. So, what's the position then in relation to Section 33? Section 33 offences are very different, and we don't accept for a moment that our concession that there is a power to prosecute for a Section 33 offence somehow introduces by the back door a power to prosecute for an incident offence. A Section 33 offence, and we'll again look at the terms as I go through my submissions, but we'll recall that a Section 33 offence is an offence directed towards securing the effective investigations by Indicom. It is an offence that creates offences for obstructing Indicom in its investigations, for committing perjury in giving accounts during the course of Indicom's investigations. It is all about bolstering the investigative function by creating criminal liability for those who seek to interfere with it.
You'd say that was the prosecutorial power was ancillary and supportive of the investigation.
Entirely ancillary, supportive of, and limited by the investigation. So not only does it fall squarely within the limited right to prosecute recognised in relation to statutory bodies, but it's also incorrect to say that the statute is silent on it. The statute isn't silent on it. Section 28 deals with it, and we will come to Section 28 in some detail. It deals with it in Section 28(1)(a) by making it absolutely clear that Indicom can use all the material it has gathered in the course of its investigations in respect of a prosecution for a Section 33 offence. And that makes it clear that Indicom itself can bring that prosecution and use that material itself. So the scheme is a coherent scheme: investigations by Indicom, prosecutions by the DPP, save for prosecutions in relation to offences created to amplify and facilitate the discharge of the investigative functions of the DPP, of Indicom, and entirely consistent with the way in which the law regards the implication of powers to prosecute.
The whole argument that may have had some influence below about a juristic person is really irrelevant to your submission.
Well, it's relevant in this sense because if it isn't a juristic person, i.e. it doesn't have a life outside the statute, then it reinforces the point that you've got to identify what it can do within the framework of the statute.
Well, there is a juristic person because the Commission is one person, the Commissioner.
Yes.
But you're drawing a distinction between the Commissioner as a private individual.
Exactly.
And the Commissioner as the exerciser of statutory function.
Exactly. So if we treat the Commissioner and the Commission as one and the same, then the Commissioner obviously has his own legal personality, and so therefore we readily concede that if there is a power to prosecute, as there is in relation to a Section 33 offence, then that power can be exercised in Indicom's official capacity, in the Commissioner's official capacity, by the Commissioner, who is an individual, or by any of the staff.
So his delegate, yes. Yeah.
Yes. But the prior question is there a power to prosecute in the official capacity of Indicom or the Commissioner, who are one and the same?
What about a member of Indicom who, by dint of the membership of that institution, acquires knowledge of a very serious crime having been committed? Can that individual, in her or his private capacity, institute a prosecution?
He can institute a prosecution. What he cannot do, and we'll see it through Section 28, he cannot rely on one iota of the material that has been disclosed or gathered in the course of the investigation. What he can do is pass that to the DPP and say to the DPP...
Oh, yes, well, I'm aware of that, yes.
Yes, I mean, you're relying on 28(1)(b), the discharge of functions. In order to get into a release from secrecy, you have to be discharging the statutory function
Yes, so you can't,
of the Commissioner.
Yes, so there has to be a prior answer to the question, what is the function of Indicom, before you can get inside 21.8(1)(b). 28(1), our submissions are, for the reasons I've outlined, it is not a function of Indicom to prosecute, and therefore you cannot appeal to Section 28(1)(b) as a means by which you can prosecute. So Section 28(1)(b) cannot be used as a bootstraps argument.
No, that's what I'm saying. Is
Yes.
In order to get into 28(1)(b), you have to show that it falls within the statutory functions of the Commissioner.
Exactly. So either it is there expressly, or it is there by implication, or it is there in the common law a la Hunt. But
So any Commissioner or member of staff wearing a private individual hat is shut off by 28(1)(b).
totally shut off. Shut off by 28.
By
28, 25 and 33, they will be committing a criminal offence if they disclose that material and use it in a prosecution. And we'll come to section 33.
Thank you.
Would that be the case in relation to material that had been made public in a report published by the Commission? Would it be possible, if you have an individual employee or officer of the Commission acting in a personal capacity, bringing a private prosecution, would he or she not be able to rely on material that had been made public, that was in the public domain?
So my understanding is that the report does not involve the disclosure of the evidence underlying the report. So you would have a report and the Indicom will draw their conclusions, but if one thinks for a moment about how on earth that could be used in the course of a criminal prosecution, it would all be hearsay. It simply wouldn't be admissible as evidence to secure a foundation for that prosecution.
Does the report not set out the material on which it's come to its conclusion?
Well, it does, but it would be on... It will set out some of it. It might not set out all of it, but it will be hearsay material. It will be a report of what the evidence is. It will not be the individual.
I'm not suggesting it should be admissible in evidence, but I'm suggesting that that material, once it's entered the public domain, could be relied on by anybody bringing a private prosecution.
Absolutely.
That's the basis for the prosecution.
Absolutely.
How it's going to be proved in court may be a different matter.
Exactly. So yes, an individual could look at that and decide that they were going to prosecute. And then I suspect what would happen is that the DPP would probably take over that prosecution on the basis that there was no evidence in order to substantiate.
But if the individual was an official of the Commission, would Section 28 be a bar in those, a practical bar in
Yes.
those circumstances?
Yes.
Why?
Section 28, in its terms, prevents... We'll have a quick look at Section 28. It prevents expressly and in its terms...
It's 932.
This is where my machine gives up on me, and I...
Shall regard as secret and confidential all documents, information and things disclosed to them in the execution of any of the provisions of the Act, subject to exception.
So then you have to look at the exceptions. So the first exception is Section 33.
Yes.
And we're not dealing with the Section 33, we're dealing with an incident offence.
And I understand your point in relation to B, that it's not a function, if it's not a function of the Commission, you can't rely on B.
So you then have to look at 2.
My point is prior to that. That is whether using material which was in a report which had already been published, and was in the public domain, would release an official from the duty of non-disclosure because it would no longer be secret or confidential material.
No, the underlying material will be secret and confidential. The underlying evidence is secret and confidential. I mean, it would undermine the whole scheme of the Act because every investigation has to finish with the production of a report. Section 28 would be OTOs if on producing a report, which must be the consequence of every investigation, the final outcome, all the material was now available. There would be no need to have a secrecy provision.
I think that all the material would necessarily be available, but some of the material would be published in the report.
So there may be a description of the material and what is said by an officer, but the underlying material itself will not be disclosed. And what is clear, if one looks at Section 28.2, because this is also a critical part of Section 28, is neither the Commissioner nor any person as aforesaid shall be called upon to give evidence in respect of or produce any document, information or thing in any proceedings other than the proceedings mentioned in subsection 25. So it's clear that the only proceedings that you can use the material that has been gathered and that is subject to the secrecy provision is in proceedings brought by the DPP. So if you, an official acting in your personal capacity, seek to try to use this material that you've gathered in the course of your investigation, you're precluded from doing so by 28.2, and 25, if we go back...
Well, as far as 28.2 is concerned, before we go on to 25, shall be called upon, that suggests shall not be compellable.
In my submission, if you look at this provision as a whole, in the context of the legislation, it is not can't be compelled, it is cannot do this at all. So they are not permitted to use any of this material in proceedings in respect of an incident offence unless it is proceedings brought under Section 25 by the DPP.
Well, now we haven't seen a report of the Commission. I don't think we've got one in our papers. But presumably, it would set out its findings of fact, its conclusions as to what had happened in a particular incident which was being investigated, as the basis for the conclusions as to whether there was any fault on the part of the serviceman concerned.
I absolutely assume it would, yes. Yeah. So on the basis of that, a private citizen or an Intercom commissioner could decide that they were going to start a prosecution. The question then is, can they use the material underlying those conclusions? Answer, no, they can't use that material. That material can find its way into a prosecution quite properly through the channel of the DPP, bringing the prosecution, following and relying upon the evidence gathered by Intercom. So
you say that even to the extent that the material is already in the public domain?
Well, the material itself is not in the public domain.
Well, it depends what you mean by material. What is disclosed in the... I'm talking about the material which is disclosed in the report.
Yes.
To the extent that that is now in the public domain, you say there's still a duty on an official of the Commission, presumably nobody else, but the official of the Commission is still under a duty not to rely on that when bringing a private prosecution.
Yes.
Right, thank you.
Where is it in
Section 19 says that you've got to...
Sorry, I've just been asked a report, which it may be that your
Right.
Lordship maybe want to see.
I don't want to take you out of your order. That might be helpful later. Thank you very much.
So, can I then start? Can I start by looking at the jurisprudence governing the powers that a statutory or other public authority has to prosecute? Those cases that show that this is not the plenary power that a private citizen enjoys, it's a much more limited power in support of the statutory or public functions. So I mentioned paragraph 10 of the Court of Appeal's judgment in Secura Plan. If we can turn to that case first, it's volume 3 of the authorities, tab 51. And that is, I'm so sorry, it's page 1868. We can just start with the single sentence.
Sorry, bear with me a minute.
Paragraph
10.
10. Thank you.
Which is on page 1872.
Yeah.
It starts with the proposition, it is of course correct that a statutory corporation only has competence to act to the extent that it is empowered by statute. And we submit that is an entirely correct starting point. What does the Act creating and bringing into being this body authorise it, empower it to do?
Body or official.
Body, official.
Yeah. I mean, the juristic person thing, I think, is a complete irrelevance.
It is a total irrelevance, because it can always act through the individuals who make it up.
So the individual is given, you say, a statutory competence qua commissioner,
Yes.
but you have to look to see what the statute has conferred on him.
Exactly. So can we go from there to I'm just going to take you to the head note because it pretty well sets out everything we need to see. So starting with the facts, the defendant authority was established under the Private Industry Act 2001, which made provision for the regulation of the private security industry. And its functions were set out in section 1.2 and included functions relating to licensing. So an aspect of regulating the private security industry was licensing, monitoring of persons providing security industry services and other services involving the activities of security operatives, and inspections of persons engaged in licensable conduct. Section 1.3 provided that the authority may do anything that it considers is calculated to facilitate or is incidental or conducive to the carrying out of its functions. So we actually have an express statutory provision here allowing it to do anything that is conducive to or would facilitate or is incidental to the carrying out of its functions.
But would you accept that is really stating what the common law would imply anyway?
Well, my position is I dispute the common law implies anything, but it's what common law principles would imply into a statute.
Into
yes.
a statute, that's right.
I accept. That
Yes.
is, that's exactly the same. And what we see is a totally consistent approach that howsoever that power is conferred, whether it be by common law or by implication, it is circumscribed insofar as it must facilitate or be ancillary to, in furtherance or support of, the statutory function.
Yes. I mean, yesterday I suggested this was the nub issue of the appeal.
Yes.
Yes, that's your position.
Yes, and that's why we've conceded that Section 33 offences are ones which can be prosecuted by Indicom, precisely because of that. So we see that, and then if we turn to the holding, the authority at 1 had power to prosecute offences under the 2001 Act on the true construction of Section 1, 2 and 3 in the context of the Act as a whole. So you've got to look, what is the power conferred in the context of the Act as a whole? And having regard to its purpose of regulating the private security industry, the prosecution for alleged offences under the 2000 Act was calculated to facilitate or was incidental or conducive to the carrying out of the authority's function. So bang within the statutory power. And then it goes on to say the functions relating to licensing were plainly facilitated by the enforcement of the sanctions prescribed by the 2001 Act. Well, that's obvious, and the same is true of Section 33 offences. To the extent that it was an offence to engage in licensable conduct, except under and in accordance with a licence, or to use an unlicensed operative, the functions relating to licensing were facilitated by resort to the threat and reality of a prosecution. Again, that's the same for Section 33. It's obviously helpful for Indicom's discharge of its functions that it can prosecute people who try to interfere with their investigations. Plainly, it buttresses their investigative function to say, you have interfered with us, we are going to make sure you're prosecuted and deterred in the future from doing so, but it'll also deter others from doing so. So plainly buttresses that function. And then they said the same in relation to the power to prosecute. They said it was also calculated to facilitate and was conducive to the function of ensuring the carrying out of inspections. And then there's this reference to something that Mr. Fitzgerald made much of yesterday, which we'll come to in a moment. The authority was in a peculiarly advantageous position to prosecute, and comparisons with other regulatory statutes in which an express power to prosecute had been conferred on the regulator were not appropriate or fruitful. So what they're saying there is, in answer to an argument that unless the power is expressly conferred, it cannot be enjoyed, or it does not arise, they say, well, no, they're peculiarly advantaged, it plainly facilitates, see Section 1.3, you don't need to have it expressly conferred, and that is the decision. We can see that they made reference in that case to Broadmoor, and I want to just look briefly at Broadmoor, because Broadmoor is the case that really sets out in the most general way the underlying principle of why these statutory bodies are able, in some instances, not in all, to prosecute. And that is at Volume 2, Tab 29 of the authorities. And it is at EB 1227. And if you look very briefly at the head note, you'll see what the problem that the hospital was faced with. So this was Broadmoor Special Hospital, and it was faced with a problem because one of its patients had written a book. And in that book, that patient identified other patients. And he gave details of their offences, he gave details of their mental states. And the hospital authority's view was that if that book was published, it would likely expose the defendant to a risk of assault, undermine his mental state, cause distress to other patients and his victims. So they went to court and they attempted to injunct the publishers from publishing the book. And the question arose, by what power could Broadmoor Hospital Authority seek the court's assistance by way of injunctive relief. And we can see at G, on page 1227 in the holding, so the first part of the holding, a public body which was required to exercise a statutory responsibility in the public interest could, in the absence of an implication to the contrary in the statute, and that is very important, apply to the court for an injunction to prevent interference with its performance of its public responsibilities, and the court should grant such an application if it was just and convenient to do so. So you start from the point that your powers are limited by the statute, but you can appeal to the court to support the discharge of the functions conferred on you by the statute, but that is subject to any implication to the contrary. So it's quite the reverse from there is a pre-existing power that can only be taken away by necessary implication. There is no pre-existing power on the part of an authority, as there is with a private citizen. Now, if your lordships can turn to page 1234 in the judgment of Lord Wolfe, and we can see at 124D, he says this case raises an issue of general...
Sorry, could you give the...
I'm so sorry, 1234. It's in your 1233?
Paragraph?
1233, at the very top of the judgment, Lord Wolfe, C to D, this case raises, paragraph 1, an issue of general importance.
Paragraph 1, thank you.
The issue is whether a statutory body is entitled to be granted an injunction in civil proceedings to support its performance of its statutory duties. And then, if you follow down and go to page 1239 in the electronic bundle, 1238 in the hard copy,
Paragraph?
and to paragraph 25
Thank you.
at G, a statute can expressly authorise a public body to bring proceedings for an injunction to support the criminal law. This is the position under the Local Government Act, section 22. In relation to many statutory functions, the power to bring proceedings can be implicit. The statutes only rarely provide expressly that a particular public body may institute proceedings in protection of specific public interests. It's usually a matter of implication. If a particular public body is given responsibility for the performance of public functions in a particular area of activity, then usually it will be implicit that it is entitled to bring proceedings seeking the assistance of the court in protecting its special interests in the performance of those functions. And we can see how the articulation of the test in later cases that the prosecution is ancillary to, supportive of, facilitates the discharge of those functions is simply a more refined articulation of that principle identified there by Lord Wolfe. So the starting point is there is not this plenary power, there is only such power as is implied. But critically, that is subject to the proviso that there is implication to the contrary, and we will show that there is not only implication to the contrary, but that the implication of a power to prosecute is directly contradicted by the express terms of the Act.
What are the public functions which Indicom have been given responsibility for performing?
What are?
Yes.
Oh, I'm going to come to the statute, and we're going to.
Well, let me put it to you that its primary function is to effectively investigate offences. And that's against the background that it was considered that there had not been effective investigation of certain species of offences in the past. If that is its function, is it not to be taken as implicit in the legislation, to quote the words of Lord Wolfe, that it's entitled to bring proceedings to seek the assistance of the court in protecting its special interest in the performance of those functions? Because otherwise, all the investigation in the world isn't going to help bring about a change in the situation that was considered to exist in Jamaica previously, unless there is an effective prosecution.
And there can be an effective prosecution by the independent body constitutionally charged with prosecuting.
Well, what's the evidence for that? What's the evidence that there has been an effective prosecution by the DPP?
That there is no evidence whatsoever that the DPP has not prosecuted where Indicom has required it to do so. There is no evidence. It's not part of the respondent's case that the DPP does not prosecute. It was not part of the case before the Inter-American Court of Human Rights, and we'll come to that case, that there was a failure in the prosecution system as opposed to a failure in the investigative system which hampered the prosecution because it didn't have the evidence. There is absolutely no evidence that the DPP constituted under Section 94 as an independent authority in Jamaica does not operate as such. Right. There is none before this court, and in my submission it would be entirely improper for this court to infer...
Oh, well, we don't like to stray into impropriety. This government.
But it wouldn't be...
Don't worry about it.
So can I then come next to the case of Hunt, which is the only case that there has been which appears to suggest that the limited power to prosecute for ancillary supportive, limited by the statutory function, is a creature of the common law. And that is at tab, core volume 2, tab 32, EB 1292. Now this is an interesting case because, of course, the Inland Revenue Commission has forever, before this case, been prosecuting individuals in relation to criminal offences arising through their failures to comply with their tax obligations. And nobody's ever questioned it, and then all of a sudden, some clever mind decided to challenge this as a basis upon which the prosecution could not be brought. And so for the first time, well, we can see for the second time, the court had to grapple with something that had been going on forever and to ask itself, well, where does the source of the power of the IRC derive from? And firstly, if we can look at what the test is of this common law right, insofar as it is a common law right, and we looked at this briefly yesterday, and that is paragraphs 28 and 29. So this is the judgment of Lord Woolf. It's a divisional court decision, and Lord Woolf refers to the case of Crown and W, in which Lord Justice Rose had given the judgment. And he says, and he cites here, a passage from Lord Rose's judgment, the revenue on behalf of the Crown have no express statutory power to prosecute, but have a power at common law in aid of their own overall functions. And then there is a reference to ex parte Mead and other materials. And then, if one then goes straight down to Lord Woolf's conclusions in respect of that passage at 29, he says this: at the end of the judgment, Lord Justice Rose added, it is clear on principle and authority that the revenue's common law power to prosecute is ancillary to, supportive of, and limited by their duty to collect taxes, i.e. another way of saying exactly the same thing as was said in Broadmoor. It has to assist the discharge of the function of the body. Mr. Fitzgerald advocated for a much, much broader test, namely one of peculiar advantage. But actually, all that at page 1300, 1299 in the electronic bundle at paragraph 20, all that Lord Woolf said there was by way of observation. It's absolutely clear that they would be peculiarly advantaged, but he did not state that the test for whether or not the common law power arises is one of peculiar advantage. The test is stated at paragraphs 28 to 29 in the clearest of terms. So the test, if there is a common law power to prosecute that sits alongside the statute's express provisions, and that is consistent with the express provisions, it is framed in exactly the same terms as an implied power. And I should say that, just want to make sure I'm right about this, that they actually were referred to to Broadmoor. Yes, they did look at the Broadmoor case in that case. So can I then look at how it came about that they identified this power as inhering in the common law? So if your lordships will turn to paragraph 17, 1209 electronic bundle, 1299 in the electronic bundle, 1298 in the hard copy. In his helpful and detailed arguments, Mr. Rhodes first contends that the IRC are a non-ministerial body of the Crown, that the body is the subject of statute and no longer has any prerogative powers, that the Crown can have no common law powers, and that there is no statutory authority entitling the Inland Revenue Commissioners to prosecute on a proper analysis of the statutory provisions which might be relied upon as giving such authority. And then this is discussed, and if your lordships then go down to paragraph 23 on page 1117, which is 1300 electronic bundle in hard copy, 1301 in soft copy, and look at the top of the page between A and B. Starting fourth line down further, Mrs. Lang does not accept the distinction between prerogative and common law powers drawn by Mr. Rhodes. She submits, and I accept, that the prerogative powers are in fact part of the common law powers of the Crown. And she referred in support of her contention to Hood Phillips' constitutional administrative law, and your lordships can see the passage cited there at the bottom of 23. I would respectfully endorse that passage as accurately setting out the position. Mrs. Lang also disputes that there is any logical reason to confine the power to prosecute in the way submitted by Mr. Rhodes. She contends that the Inland Revenue Commissioners may have a distinct constitutional existence, but they are still officers of the Crown. And so, in my submission, this case is sui generis. There is something peculiar about the Inland Revenue Commission as an authority, precisely because it is an emanation of the Crown, or it is an aspect of the Crown, and therefore it enjoys prerogative powers. But what's important is the principled approach that the courts take. We have an implication of a power by statute, which is identical to what the common law permits by way of exercise of a prerogative power, and that is that the power must support, facilitate, be ancillary to, and limited by the particular function the body is performing.
Did the fact that the Inland Revenue was an emanation of the Crown have any bearing on the ultimate reasoning in this case at all?
In this case?
In Hunt?
Yes, in my submission, that is the basis upon which it found that the duty inhered. It notes, so Lord Wolfe notes...
You've read, he narrates Mrs. Lang's submissions, but where does he pick up and say that they are instrumental in his decision?
In my submission, if you read down through the rest of the paragraphs, it is to that effect. And what is then said in respect of paragraph 28, it is said in terms that Lord Justice Rose, did not look directly at the issues discussed above. So he didn't look directly at the question of where the power derives from and the fact that the Crown, the IRC is an emanation of the Crown, but he nonetheless adopts his conclusions as to what the nature of the power is. So if I can leave your lordships to read the rest of those passages in your own time, in my submission, the effect of that judgment is that it is from the prerogative power enjoyed by the IRC as an emanation of the Crown that this power at common law derives. But in any event, And critically, the nature of the power is identical to the principles which govern when a power is going to be implied, and it is limited in the ways that we have identified, and of course its coexistence alongside a statute is entirely dependent upon whether or not it is inconsistent with its express terms and the statute construed as a whole. Can I turn then to Rollins, which is Core Volume 3, tab 50. And that's at page 1855 of the electronic bundle and 1855 of both, the hard copy and the electronic bundle. And if your lordships can take from the head note, firstly, if your lordships can just read down through the head note.
And the holding.
And the holding, please, yes.
Yes.
So here we have a slightly different situation in which we have a body corporate, and so as such, its powers are defined by its memorandum and articles of association. And it therefore has, insofar as it is able to prosecute, consistently with those articles and memorandum of association, it is able to prosecute in aid of discharging its functions. And the question in this case was simply whether or not a statute which had identified or created certain criminal offences and specified that the SFA could prosecute in respect of those had thereby limited the prosecutorial powers it would otherwise enjoy. And the court held, no, it does not, because those other prosecutorial powers remain, ones which are exercisable pursuant in order to discharge the body's functions. And there's nothing obviously inconsistent with the statute that those more plenary powers should be maintained. The final case I want to take your lordships to on this is the case of Stedroy Benjamin, which was a case that was relied upon by the appellants in support of its argument. That is at Core Bundle 2, 30, tab 30, page 1247. And the issue is identified at paragraph 1 on page 1250, 1249 of the hard copy. Does the Director of Public Prosecutions have a general power to prevent the police from instituting criminal proceedings? And we move through to paragraph 16. The common law has conferred a power to institute criminal proceedings on every citizen, and when at first they instituted such proceedings, the police exercised that general power. But the power of the police to institute criminal proceedings has been buttressed by statute. And then reference is made to the statute. And then, if your lordships, that's in paragraph 17 and 18, and if your lordships continue down to 21 and 22, the provisions of the Constitution are central to the issues raised in this appeal. Counsel for Mr Benjamin contends that either expressly or implicitly they confer power on the Director to prevent the police from instituting criminal proceedings. And it is agreed that if his contention is correct, the duty of the police to institute such proceedings in circumstances specified in Section 23 of the Police Act, and their power to do so at common law under the Magistrates' Code of Procedure Act are qualified accordingly. 4 Section 2 of the Constitution provides it is the supreme law. And then in paragraph 22, the Constitution, the relevant sections of the Constitution creating the office of the DPP are set out, and this is identical to the provisions of the Jamaica Constitution in relevant respects. We can see at 88(1)(a) there is a power to institute and undertake criminal proceedings against any person. At B, a power to take over any and continue any such proceedings that may have been instituted, and at C, a power to discontinue. And then a subsection 4, a provision for the DPP's powers to be exercised through anybody that he shall direct. And then, if we turn to paragraph 23 of the judgment, on these sections, the board makes the following preliminary observations. Section 88(1)(a) confers a power on the DP director to institute any criminal proceedings in any court other than a court-martial. If he exercises this power, he does so in his own name. In that, it is a power rather than a duty he can elect not to exercise. In other words, not to institute such proceedings. Section 88(1)(b) and C expressly recognises, as does the proviso to Section 88(2), that criminal proceedings can be instituted by any person or authority other than the director. And then 24, key passage, the primary contention made on behalf of Mr. Benjamin before the board is that Section 88 of the Constitution expressly empowers the director to instruct the police not to institute criminal proceedings. In this regard, counsel relies on subsection 1A and or 4, and unsurprisingly, your lordships gave this very short shrift, given the terms of 88, 2 and 3. With respect to counsel, it's hard to dignify the contention as even being arguable, and if your lordships just read down to the end there. Now, we readily accept that the DPP cannot prevent anybody who is empowered to bring a prosecution from doing so. But the question in this case is Indicom empowered to bring a prosecution? And so this case has no bearing whatsoever on the issues that your lordships have to decide, because Indicom is not a private person, but a creature of statute who only enjoys the powers conferred or implied, applicable under the common law insofar as they are consistent with the statutory scheme. So can I then turn to the Act itself? And I'm sorry that we're going to have to look through this in some detail, because it really does provide a very clear code as to the nature of Indicom's functions.
Well, it's critical to your case.
It's absolutely critical. We have to construe the statute in context. So can we turn then to Volume 1, Tab 8, which is at page 912 in both the electronic and the hard copy of the electronic bundle. And if we can start with the long title, which is at page 914. An Act to repeal the Police Public Complaints Act, to make provision for the establishment of a Commission of Parliament, to be known as the Independent Commission of Investigations, to undertake investigations concerning actions by members of the security forces and other agents of the state that result in the death or injury, or that result in death or injury to persons or the abuse of the rights of persons, and for connected matters, connected. So, very clear from the long title, this is a statute which is creating an authority whose function is to investigate. And then there are some definitions in section 2. And we can see it 2. The first definition, commission, means the independent commission of investigation constituted under section 3, and the commissioner is the person appointed pursuant to to section 3 as commissioner. And a complaint is there identified. Concerned officer shows that this act covers not just the Jamaica Constabulary Force, but also the Defence Force and the Island Special Constabulary Force and the Rural Police. And a concerned officer is one of those about whom a complaint is made. And a concerned official means the specified official about whom a complaint is made. Constitution, that of Jamaica. And then if we look down to incident, it means any occurrence that involves misconduct of a member of the security forces or of a specified official, which results in any of the following. And we can see that this isn't just set up to look into death or injury of any person, and those are obviously the most serious occurrences that Indicom is going to look into, but it also is looking into sexual assault, assault or battery resulting in damage to property, and anything not falling within A to D, which in the opinion of the Commission is an abuse of the rights of a citizen. So my Lord Kerr mentioned before that this is a body that's being constituted in order to investigate whether offences have been committed, and that's not actually entirely correct. It will look at whether offences have been committed, but it's also got a very important remit in looking at whether or not there's been misconduct short of the commission of offences, which may give rise to disciplinary issues, just in the same way as our Independent Office of Police, our IOPC, Independent Office of Police Complaints, does under the Police Reform Act here. It doesn't just look at the commission of criminal offences, it looks at disciplinary offences as well.
Well, I hadn't intended to exclude that in my loosely phrased question. Yes?
Turning then to paragraph 3, and section 3 rather, and section 3 is one of those sections that section 20 is concerned with, where section 20 confers a power, we'll come to it in a moment, confers on Indicom the powers of a constable in the exercise of its functions under sections 3, 4 and 14. So, section 3. For the purposes of this Act, there is hereby constituted a Commission of Parliament to be known as the Independent Commission of Investigations. And then subsection 2, this is where it's provided for that it will consist simply of the Commissioner, and it sets out how the Commissioner shall be appointed.
I think it's, in fact, refers to sections 4, 13 and 14, doesn't it?
Oh, sorry, I'm so sorry. Yes, it's 4, 13, 14. Thank you. I'm sorry. Subsection 4. So this is one of the ones to which section 20 refers. So the functions of the Commission is what this is concerned with, we can see in the side note. Subject to the provisions of this Act, the functions of the Commission shall be 2. Conduct investigations for the purpose of this Act. Carry out in furtherance of an investigation, and as the Commission considers necessary or desirable, inspection of a relevant public body or relevant force, including records, weapons and buildings. Periodic reviews of the disciplinary procedures applicable to the security forces and specified officials, and to take such steps as are necessary to ensure that the responsible heads and responsible officers submit to the Commission reports of incidents and complaints concerning the conduct of members of the security forces and specified officials. So a report of an incident is a report about something having happened which falls within the remit of the body's investigative functions, and the complaint is something made by a person external to the force about some conduct on the part of the police that falls within the remit of the Indicom's investigative function. In the exercise of its functions under subsection 1, the Commission should be entitled to, and we can see the powers that are given to it there, have access to all reports, documents or other information regarding all incidents and so forth. And if your Lordships read down. And subsection 3, a further set of powers conferred upon it to, upon the authority of a warrant issued in that behalf by a Justice Peace, to have access to records, documents and other information. So these are all powers that are conferred to support Indicom's investigative function. That being the only function expressly identified in 4A, the other functions in 4B and C being functions to be undertaken in furtherance of the overarching investigative function.
You say 4A, 4.1A and B, yes.
I'm sorry?
4.1A.
4.1A, yes, I'm sorry. 4.1A. So, the Commission's independence is guaranteed under Section 5. And then at 7 and at 8, the officials of the Commission are established, a Director of Complaints, and then provision is made for the appointment of employees to undertake the work, the investigative work on behalf of the Commission. We then turn to paragraph 10, and this is the complaint that was referred to earlier on, and it sets out what a complaint is. And your Lordships can see that that mirrors the matters about which Indicom is established to investigate. And at 10.3, when the Director receives a complaint, Director of Complaints, then, amongst other things, at 3B, he must cause an investigation into the complaint to be made forthwith. And if, in the opinion of the Commission, the conduct complained of constitutes an offence, forward a copy of the complaint to the DPP forthwith. So, my Lord, where, out of the myriad complaints that might be brought, it is of a nature that discloses an offence, we can see the first involvement of the DPP.
Now, supposing the DPP declines to take the matter further?
At this stage or at any stage. So at this stage, the DPP doesn't have to do anything. This is just notifying, and it's before the investigation has happened. But if I take your question further, my Lord, let's imagine a situation where a report has been prepared.
Which, in the opinion of the Commission, clearly discloses an offence, and the DPP fails to act on it.
So he sends the report to the DPP, and it includes a recommendation that the DPP should prosecute, and the DPP fails to do so. Then what he can do under the Act itself is to raise the matter in Parliament, but also, arguably, could judicially review the DPP.
Right.
Because one of the functions is to make recommendations. And so in support of that function of making recommendations, he could seek the assistance of the court to look at the legality of the decision to refuse to prosecute.
But you would say it wouldn't go so far as to include an ancillary power to prosecute itself?
No. No. And when one steps back and looks at this, the state is made up of numerous myriad different bodies. And it must discharge whatever obligation is imposed on international law. It can choose to do so by creating an investigative authority and a prosecuting authority. If the prosecuting authority is not doing what it should do, then you have to look at what means there are available to make the prosecuting authority do what it should do. It does not entail that the investigating authority must do it. There are other practical...
Perhaps not must do it, but may do it.
May do it, but there is a distinction between, as a matter of principle, the investigative body must do this to discharge, as a matter of principle, it must do this to discharge the investigative duty imposed under international law. And then there is the question, well, what happens in practice? In this particular state, is it failing, or is one arm that is perfectly, or that has been established in accordance with those principles to discharge one aspect of the duty? If, as a matter of practice, it's failing to do so, then the question is, what do you do? Now, the appellants would say you have to reinterpret this legislation in order to suddenly find some kind of right to prosecute. And our submission would be, no, you don't reinterpret the legislation, you tackle the independent investigative body and make sure that it starts operating independently. But in any event, we don't even begin to get there in this case because there's no
I think you mean
question.
DPP.
Oh, sorry, independent prosecutorial.
Yeah.
I'm so sorry, yes. But we don't even begin to get there in this case because there's no question that the DPP is independent. She is a body constituted under Section 94 of the Constitution. So one has to distinguish the practical from the principle, and this piece of legislation needs to be construed by reference to legal principle. What is required as a matter of law of the state in terms of its investigative and prosecutorial machinery? Does it need to establish a single body having both powers or both duties? And the answer...
It may be that you don't have an answer to this question immediately, and by all means take instructions if indeed instructions are available. But has there been a challenge by Indicom to the failure of the DPP to take proceedings?
Apparently there has been a number of.
Challenges. Well, we might hear more of that later. Thank you.
That in itself shows that the machinery is working of the state.
Well, but it depends.
Depends what the result of the challenge is.
Yeah.
Well, if the court says there should be a prosecution, the DPP erred in that case, then unless the error is founded on the basis that in some way the DPP has acted in bad faith, as opposed to made an individual error in the way in which the DPP has evaluated the evidence, then it shows that the machinery of state is working. It is only if
it
the
depends.
DPP...
As my Lord says, it depends, because judicial review as a means of challenge, of course, has its limitations. And one would need, I think, and it may not be possible to achieve this, one would need to have a fairly comprehensive information about the basis on which the DPP's decision not to prosecute has been challenged by Indicom and the outcome of those challenges. But I mean, you make the perfectly legitimate point that certainly at a theoretical, technical level, there is a means of challenge. And that's incompatible, you say, with there being a need for an extending to Indicom a right to prosecute.
And the appellant has put forward no evidence to show that the DPP is, in some sense, failing to discharge the core constitutional duty of her office, which is to act independently. There is no evidence whatsoever.
Well, even if there were such evidence, it's questionable, I think, whether that would inform the proper interpretation of the legislation.
I agree, yes, but I would also add this. Our courts are very, very careful about interfering with the office or the exercise of a prosecutorial decision by our DPP and CPS. And it's precisely because of the independence of the DPP and their special expertise in prosecuting that it does so. Now, in my submission, it would be wholly wrong to conclude that from a number of JRs where the DPP's decisions have been quashed because of an error in her analysis of the evidence, that she is not acting independently and effectively in that regard. But if and insofar as those did show that she was making decisions that were palpably erroneous and irrational, then the answer to that is not to rewrite this statute. The answer to that is to make sure that the DPP's office is, or the failings are addressed, and that those prosecutors who are making misinformed decisions are properly trained.
Unless one can infer that there is this ancillary power in the light of the rather peculiar and extremely striking background to the introduction of this Act itself.
In my submission, the answer to that is no, and I will take your lordship soon to the case that led to the introduction of the Act, and what we'll see in that case is an abject failure in the investigation, a shocking failure in the investigation. So far as the prosecution was concerned, there was no challenge to the prosecutor's independence, the failings in the prosecution were all ones which arose because the prosecutor was hampered by the failings in the investigation. In other words, because the investigation was so flawed, the prosecutor was not provided with the material that enabled her to say, I need to charge A and B because the evidence has been established to show that they... So there was no complaint in that case about a failure as to the effectiveness, as in the institutional, systemic effectiveness of the prosecution, as opposed to its inefficacy in the particular case because of failings that preceded the role of the prosecutor. And that's incredibly important because that is the background to the introduction of Indicom and of the Indicom Act, and the Act is entirely consonant with the criticisms and focuses itself upon the investigative function because the prosecutorial function was not impeached by the Inter-American Court Commission for Human Rights at all.
And you'll come to that.
And I'll come to that.
Thank you.
Ms. Kaufman, I'm puzzled why the judicial review proceedings to which you refer help you. If Indicom can bring judicial review proceedings, that must presumably be in the absence of any express arguments. That must be because doing so is conducive to the fulfilment of its functions. But if the judicial proceedings, the judicial review proceedings, are entirely about someone's failure to prosecute, why does not the prosecution of offences revealed by Indicom's, the effective prosecution of offences revealed by the investigation, form part of the functions or things which are conducive to the fulfilment of the function?
Because the answer to that lies in the fact that Indicom has under the Act power to make representations and recommendations. So it makes a recommendation. That recommendation is not acted upon. And so it is ancillary to that. It is trying to give effect to its power to make recommendations. And that is an express power it has under the Act. And that distinguishes it entirely. And of course, the other point to make is it's not just Indicom that could bring a JR, but also the victim, the victim's family, anybody who is the beneficiary of a report by Indicom that says there should be a prosecution, and there isn't, and they can bring judicial review proceedings as well. So can we then move on to Sorry,
maybe a further answer to my question is the fact that if the Commission do bring proceedings, do institute a prosecution, the DPP can take that over anyway.
yes, they can, but the question is, can they institute a prosecution in the first place?
No, of course,
Yeah.
yes, but the fact that they can take it over, the DPP can take it over, may be a further response to the particular point that I put to you. And then the only, if the DPP were to take it over and drop it, then the only recourse would be presumably judicial review.
To have to judicially review, yes.
Decision not to pursue
Not
it.
to pursue it,
Yeah.
exactly. Yes, if there was that fundamental difference of view about the evidence.
Yeah.
Yes, absolutely. So, Section 13. So the Commission may initiate investigation, and that's Section 13. An investigation under this Act may be undertaken by the Commission on its own initiative. And then 14, the Commission shall, for the purposes of deciding the most appropriate method of investigation, make an assessment of the seriousness of the case, the importance of the investigations, public interest considerations, the particular circumstances. And then this is how, at 14.2, Indicom carries out investigations. It may manage, supervise, direct and control an investigation carried out by the security forces or the relevant public body in relation to an incident where, in the opinion of the Commission, it is necessary to direct and oversee that investigation. So it can itself investigate, or it can investigate in these different ways. It can manage an investigation, which is going to be actually carried out by the force itself. It can supervise an investigation, which is going to be carried out by the force itself, and it can direct and control an investigation. Now, direct and control does not mean investigate for itself. It is directing others as to how to conduct the investigation. And this is, in fact, on my understanding, exactly how the Act works. What happens is that Indicom decides what's going to happen, is it going to be a managed, supervised, directed and controlled investigation that the security forces or the police themselves are going to undertake. And there are protocols that have been agreed between Indicom and the Commissioner of Police that set out how the police force is to assist Indicom in discharging its investigative function. For example, in respect of the holding of ID parades. For example, in respect of, as we'll see, the inspection of weapons and the management of weapons. There are numerous protocols by which Indicom seeks and obtains the assistance of the police. And the police do assist. For example, here's another example. When the police want to when Indicom wants to question a particular officer, then arrangements exist under a protocol whereby the police force secure the attendance of that particular officer for the purpose of being questioned.
Does this mean that the Commission doesn't have its own staff to
It's too small. It does not have sufficient resources itself to do all the investigations. And again, this is not entirely distinct from the situation that obtains in England and Wales. There are investigators within the IOPC in England, and there are, in some of the most serious investigations, then everything will be carried out by the IOPC itself. But they also enlist the assistance of the police forces themselves. So in Jamaica, there simply is not the resources for Indicom to do all of this itself, and it doesn't do so.
But I think you would go further and say that the implication of Section 14, subsection 2, is that the limit of the powers of the Commission is to manage and supervise investigations carried out by the security forces or the relevant public body.
Yes, I think the strongest form of investigation is direct and control. So where it directs and controls as opposed to simply supervises, that is the strongest. But again, it's not...
But that's still by an agency other than the Commission itself.
Exactly.
Well, the Commission's got a series of directors of complaint, as I understand it, for different regions. Is that right?
Yes.
But beyond that, it has a very limited staff.
Yes. So there then follows a number of provisions concerning the way in which an investigation can be avoided, and there may be an informal resolution. We can see that in section 15. And we come down to section 17, where there has been a failure. I'm going to skip anything to do with the DPP at the moment, and I'm going to come back to those provisions, if I may, later. So 16 does have a role for the DPP, but 17, we can see that where this now addresses formal handling of complaints, so where it's not been possible to informally resolve, subject to subsection 2, where a complaint is not resolved in accordance with section 15 or 16, the Commission shall cause an investigation to be made forthwith into the complaint. Cause an investigation to be made. And this makes the point made by my Lord Kerr that they are not investigating, they are causing the investigation to be made. The Commission is not required to conduct an investigation where it is satisfied that in the circumstances of a particular case the complaint may be justly and adequately resolved without that. And if you will then go down to subsections 5 and 7, and read those. It's dealing with the reports that have to be prepared and submitted following the completion of an investigation. And if you follow 7 right through to 10, so the report is the culmination, and you can see it has to be served at subsection 10 on a large number of bodies and officials, including the DPP.
Are there any provisions for general publication or wider publication?
There are, yes, at 19, on the application of a person to obtain access to the report of the Commission, grant such access if it is satisfied there are no compelling reasons for denying access.
Thank you.
Yes, so access is given, but it's not published for generally.
So access is given at the discretion of the Commission, which is subject to them not considering there are good reasons not to. Then, if we, at section 18, we can see that the Commission has a discretion to hold hearings, but it needs to consult the DPP before it does so. Now, we submit that that's relevant for the obvious reason that the holding of hearings could interfere with the subsequent prosecution, and the DPP ought to know about it, which again feeds into the scheme of this Act, that it's the DPP that deals with prosecutions, not Indicom. Section 20, powers, authorities and privileges, for the purposes of giving effect to sections 4, 13 and 14. So 4 confers the investigative function, 13 and 14 are concerned with investigations of the Commission's own initiative and
I see in section 20 it refers to the investigative staff of the Commission. It rather suggests that there is available to the Commission its own staff to conduct investigation.
Yes.
I'm sorry.
I don't think you're not denying that the Commission can carry out investigations without involving security forces. But what you're saying is that the reality, given the limited number of staff, is that they have to rely
Absolutely.
on the manage, supervise and direct
Yes.
part.
And that's why all the protocols have been agreed, because in practice that's what they have to do. And the Act provides for that, but I'm certainly not suggesting that they couldn't themselves decide that they are going to carry out an investigation from start to finish entirely.
Well, section 20 clearly envisages that.
Exactly.
Well, I'm sorry, I've obviously misunderstood your earlier answer, but that's my fault, I'm sure.
No, I've no doubt it is my fault for not making it clear. I was simply making an observation about the practical reality and the fact that the Act makes provision for this. But the point about section 4, about section 20, is the powers conferred, i.e. the powers of a constable, are solely for the purpose of giving effect to the investigative functions of the of Indicom. So next, section 23. Now this is concerned with recommendations. And if I can leave your lordships just to read that entire section.
Yes.
So those are recommendations specifically to the relevant force or relevant public body. So we're not talking about recommendations made to the DPP, and we can see that there is a duty to secure compliance with those or to explain why there has been non-compliance.
Yes.
And then we have the provisions. I'm going to take you to section 25 now. This is the role of the DPP. An investigator shall, on a request by the Director of Public Prosecutions in relation to a prosecution arising out of an incident offence, attend court and provide such other support as the Director of Public Prosecutions may require in relation to the proceedings instituted against the concerned member or the concerned official under the Act. So an express provision requiring assistance by Indicom to a prosecution to be brought by the DPP. In our submission, this is a very important provision which sits with the others we'll look up in a moment, which is distinguishing the investigative function expressly conferred on Indicom from the prosecutorial function, which the Act clearly contemplates will be discharged by the DPP, and thereby to make that a duty or power on the part of the DPP efficacious requires Indicom themselves to cooperate. And then, if we move down to section 28, this is another key provision to be looked at in context in order to understand whether or not a power to prosecute can possibly be implied or sit alongside the Act as an aspect of the common law. So I know your Lordships have looked at this again, but I'd just ask your Lordships to do so once more in the context of the Act as a whole, which we've now looked at. So, everything disclosed is secret and confidential. That's disclosure of information, documents, or things. It's all confidential unless, at A, the disclosure is made by the Commissioner or any such person in proceedings for an offence under Section 33. So there is an express contemplation of a prosecution under Section 28(1)(a). And it is a prosecution for a Section 33 offence. Now, if Parliament had intended that the Commissioner could use that evidence for the purpose of prosecuting an incident offence, why not say so there? Parliament doesn't say that. Instead, Parliament says at section 28(2), neither the Commissioner nor any person of the persons aforesaid shall be called upon to give evidence in respect of or produce any such document, information or thing in any proceedings other than proceedings mentioned in subsection 1 or section 25. Now, in my submission, having allowed the Commissioner to make disclosure despite the secrecy and confidentiality for the purpose of a subsection 1 proceeding, having allowed the Commissioner or required the Commissioner under section 25 to assist the DPP if the DPP prosecutes for an incident offence, the only sensible way to understand section 28(2) is it's not a protection from compelling the Commissioner to disclose in any other proceeding. It is a prohibition on the Commissioner making any disclosure whatsoever in any proceedings other than those specified in 28(2), namely those in subsection 1 of section 28 and those in section 25. So in our submission, by its express and clear terms, section 28, and seen in the context of an act which clearly confers only an investigative function, plainly envisages a role for the DPP in order to prosecute offences that arise from those investigations. Section 28(1), seen in context and by its express terms, makes manifest that Indicom cannot prosecute for an incident offence. In contrast, by its express terms, it can prosecute for a section 33 offence. And that leaves section 28(b).
28(1)(b).
Sorry, I'm so sorry, 28(1)(b), which, as we discussed before, cannot be a bootstraps provision. It refers to function, and the question of what function Indicom has, or functions it has to be determined by construing the Act as a whole, including the provisions of section 28. And when that is done, it is absolutely clear that function does not include prosecution for an incident offence.
So they can disclose information which has been disclosed to them in the course of their investigation for the purpose of pursuing the investigations themselves. So if they need to disclose something they've been told to somebody else in the course of the investigation, they can do it.
That's the perfect example. So, for example, they're about to question an officer who they suspect. has used unlawful force. They have a witness who has written a statement, a member of the public, and they need to disclose to that officer what the witness has said. It's an obvious reason. There may be myriad reasons why in the course of their investigation they need to make that disclosure. It is not contemplating, but whether it's contemplating or not, it does not extend for the reasons I've given to prosecutions for an incident offence, because they are entirely inconsistent with the scheme of this Act. There are a couple of other provisions I just want to take your...
Just before you go, presumably you accept that 28(1)(b) would be the statutory authorisation to use relevant information in bringing an application for judicial review against the DPP.
Exactly. If you were bringing an application for judicial review, you would have to be able to show the court what it is, absolutely, what the evidence was and why that decision was therefore.
And you'd have to show, for example, what it was you sent to the DPP.
Exactly.
Yeah, so 28(1)(b) could facilitate disclosure within the investigative process itself, telling B that A said this to him, and then, but you concede it goes further to extend to the JR.
And it would, yes, because the JR, there would be no means of accessing the court properly if you couldn't then use the Section 28(1)(b) power in order to make good your case. So, can we move to Section 33?
Just before we do that, the other point I suppose you would wish to make is that Section 28, in its use of the term functions, must be taken to refer back to the list of functions specified in Section 4.
Absolutely.
It would be unusual to import into Section 28 a function other than those particularly specified. Sorry, you're going to take us to Section 33.
Save for those that are ancillary to...
Yes, quite.
...and supportive of that primary function.
Right.
So...
Yes, functions are defined, I think, as including, including powers and duties, but nothing, I think you think, turns on that.
No, nothing. So can we...
That rather odd definition just takes you round and round in circles.
Yes, so it seems to.
I tried to go down that road and I keep ending up where I started.
Section 33. So for the first part of Section 33, that's A and B, we will look at in Diah, and that deals with creating, that creates a number of offences relating to obstructing Indicom in the course of its investigation. I want us to look at Section 33C, and this provides that every person who deals with document, information or things mentioned in Section 28 in a manner inconsistent with his duty under that section commits an offence and shall be liable on summary conviction in a resident magistrate's court to a fine. So if Indicom does start its own prosecution and does try and rely upon the evidence, contrary to Section 28, 1A, 1B and 28.2, they will be committing a criminal offence. And in our submission, if the matter needed to be put beyond doubt, this puts it beyond doubt. Section 34.
Well, unless, of course, and this is why we'll come back to function again, unless the prosecution is supportive of the functions.
Well, of course, unless, but my primary submission is...
Oh, that it's not. No,
you look at the statute as a whole, and it is absolutely not an aspect of its functions. It's inconsistent with the Act that it can be one of its functions. And then, of course, the fallback position is that it doesn't meet the test of implication or the common law test in Hunt. It simply is not ancillary.
Yes, right. I think my last point is that Section 33 isn't going to necessarily give us the infallible answer, but it's part of the fabric of your...
The fabric.
Yes.
Exactly. It is part of the overall fabric. So put it all together and there is only one conclusion one can come to. Now, there's Section 34. I must address this section because it's something that's relied upon, and then I can move on to something else after the lunch adjournment. But this is something relied upon by the appellant. Nothing in this act shall be construed as limiting or affecting any remedy or right of appeal, objection or procedure given to any person by any other provision of law. Well, my primary submission is that there is no power of prosecution given to Indicom absent the Act. So if I'm right about Hunt, and Hunt is a special case applying only to the Crown or an emanation of the Crown, then there is no such power that is being taken away. But in any event, this can only bite upon such powers as are capable of surviving the express terms of the statute. And insofar as the statute is in conflict, we go back to Broadmoor, inconsistent with its terms, then Section 34 doesn't bite at all. So, my Lord,
it would be quite a big thing to construe or procedure, you would say, as including the bringing of prosecutions for incident offences, bearing in mind it comes at the end of a long list which starts with remedy or right of appeal, objection, ... or procedure.
Well, I can imagine it might be argued that a prosecution is a remedy.
Yes, okay.
Seeking a remedy of the court.
Yeah.
But the point is, you can't do it because it's only the statute that gives you the power. You don't have a pre-existing right. Or, if I am wrong about Hunt, and Hunt applies generally to public authorities as opposed to Crown bodies, it only applies insofar as, I'd have to also be wrong that it's ancillary and supportive. I'd have to be wrong about that. My primary submission is it's not ancillary or supportive to prosecute, but it has to survive the express terms of the statute. It mustn't be inconsistent with those terms. And for the reasons I've given, it is entirely inconsistent with the terms of the statute. So Section 34 is not an answer either.
Would it extend to the entitlement of an individual or an official in his private capacity to bring a private prosecution?
Yes, but that individual could not use, because of Section 28, any of the material that individual had obtained in the course of the investigation.
I realise there's an issue in relation to that, but is Section 34 not broad enough to say that nothing should be construed as limiting or affecting
Absolutely.
the ability of the individual, or the remedy of the individual, if it is a remedy, to bring a private prosecution?
Absolutely. I have no issue with that, because this simply, so what they're meaning by that is the fact that the fact that Parliament is creating an investigative body with these investigative functions and providing for prosecutions by the DPP under its terms, with the benefit of the evidence that is gathered in the course of the investigation, does not stop a private person or an Indicom official in their private capacity seeking to prosecute.
But Section 28 does.
Section 28.
Yes. Thank you.
In the official capacity, Section 28 prevents Indicom from prosecuting.
I understand that.
And therefore the Commissioner from doing so on behalf of Indicom in his official capacity.
But Section 28 might limit the private individual's
Exactly.
ability.
Exactly.
Exactly.
Precisely.
But you say you have to construe Section 34 in the light of that, and it doesn't override Section 28. I imagine that's your submission.
Exactly.
Right, that's probably a good place to break off. Sit again at 2 o'clock.